Good morning, everyone. Now call Professional Registration and Licensing Committee to order. Madam Clerk, please call the roll.
Chairman Coleman.
Here.
Vice Chair Dinkins. Representatives Brown. Cook.
Here.
Davidson. Davis. Dahl. Grier. Kelly. Lewis. Riley. Roberts. Smith. Thomas.
Very good. We do have a quorum, so we are going to start out with executive session. But before we go in, I want to just remind everyone of some of the rules. Last week, we got into a little bit of an issue because we had a caucus meeting that fell right in the middle of our committee. Why they do that, I don't know. But I appreciate everybody's patience for last week. Just want to remind them that we are going to limit everyone to 5 minutes for testimony. If we get into something that we feel we want to go a little bit deeper, that's my prerogative to let that continue to go, but we are going to keep everybody to 5 minutes as much as we can. That goes for questions to our witnesses committee. So if you have a question for everyone here to the witness, that's a 5 minute period, and we will be timing. Once again, if you do have an amendment that you would like to put on a bill, please have that to my office 24 hours in advance so that we make sure that we get everything correct. So with that being said, we will now move into executive, and I move that House Bill 2138 be due pass. Is there any discussion? Yes, Representative Kelly. Very good. So Representative Kelly has an amendment to our House Bill 2138. Oh, I'm sorry, a House Committee sub. So this is, I apologize. Representative Kelly has a House Committee substitute for House Bill number 2138, ending in .02C to offer, and it has been distributed, and I move for its adoption. Any discussion? You should have a copy. Yes. It's like a book, by the way. Very good. Representative Lewis.
To inquire.
Proceed.
Can you explain the changes in the House Committee sub, please?
So I think it is on page 15. If Representative Smith will, all it is doing is adding the reciprocity language so it matches the national language and does not go against the 2020 language that we passed out of the House and out of the Senate in 2020.
Okay. And then are there any concerns with the compact language? With
everything stays intact with the compact. It's just adding that reciprocity language in.
Okay, great. Thank you.
And that begins, I can tell the exact same page it begins. Page 14 with sections 345.052. And that reciprocity language ends on page 16, right before 345.170, I believe.
Thank you.
That's the only thing that was done.
Any further questions or discussion? Yes, Representative Grier.
Very briefly and publicly thank the bill sponsor and the department for working on this and coming up with the correct language so that we can maintain that license recognition.
Very good. Thank you very much for that recognition. Any further discussion? Seeing none, all those in favor of adopting the substitute signify by saying aye. Aye. All opposed, same sign. The ayes have it. You have adopted the substitute. I now move that House Committee substitute for House Bill 2138 be voted due pass. Any discussion? Seeing none, Madam Clerk, please call the roll.
Chairman Coleman,
Aye.
Vice Chair Dinkins, Representative Brown, Cook, Davidson, Davis, Dahl, Grier, Kelly, Lewis, Riley, Roberts, Smith, Thomas.
By your unanimous vote of 13-0, you have voted House Committee Substitute for House Bill number 2138 do pass. That concludes our executive session. We'll move into our regular open hearings. And we will hear, once I get to it, House Bill 2434 by Representative Grier. Well, we'll continue our hearing. I guess I don't know if I'm using the right language. We will continue testimony from last week on Representative Grier's bill. We ended last week with opposition, so we will continue the opposition this morning. So anyone here, let me explain to you what I'm going to do today. We're going to go ahead and take the remaining opposition. I will come back to anyone here that did not testify last week in favor of, and then we'll go to informational purposes only. So anyone here today that did not testify last week in opposition, now is your time. Thank you. If you'll state your name and who you represent, and you do have a witness form, it looks like. I appreciate that. Thank you very much. And if you can make sure the green light is on the platform right there for the microphone. Can you pull that a little closer to your face, please? There you go.
I'm Dr. Kiekhaefner.
Led team. Ooh, well, they said it was lit. I was like, I don't know. Anyway, I feel this way because I have seen the whole range of nurse practitioners in the time I've been there. I have a nurse practitioner on my team who's worked 20 plus years as a nurse practitioner. Before that, she worked as an ICU nurse and as a floor nurse and as a nursing instructor for 10 years before becoming a nurse practitioner. However, these days, a lot of the nurse practitioners that we have are a year or so out of nursing school. They have very little clinical experience. They decide they want to do this. They don't want to apply and go to medical school, so they do a 2-year, 3-year online program. They maybe do a clinical for a day or two, once a week, weekly for some months, and then they do maybe a 3-month practicum when they're in the office every day for 3 months, and then they license and then they launch. Anybody who brings on a nurse practitioner who's just started, just licensed, knows that they themselves will be taking on being the residency and internship for that nurse practitioner because they have had very, very little clinical experience. I'm quite concerned that there's a move to making them being launched without any supervision. you know that you're going to have a lot of questions, you're going to have a lot of checking, you're going to have a lot of teaching, you're going to have a lot of bringing them along. What we did as doctors, when internship and residency with many levels above us, senior residents, attendings, all sorts of training, guiding us. Nothing was done that wasn't signed off, like in the clinic. They don't have that when they go out, and they barely had any clinical training. So I don't think that the independent practitioner, as a nurse practitioner, is a safe thing for Missourians. Now, I know people are wanting to provide more practitioners for the rural areas, but studies have shown that they don't go to those rural areas by themselves. There's less than, let me see, I want to get the numbers right. Well, in Arizona, where they have independent practitioners, only 11% of them are in rural areas. And so we're not getting provision by approving this. I think of the difference in my clinical experience, and I still felt as a new doctor going out that I needed to talk with my colleagues, check with them, be verified about what I was doing. And, we had over 10,000 clinical hours before we hit practice by ourselves. And these nurse practitioners, as wonderful as they might be, eventually are just neophytes. They get maybe a 500 or 1,000 clinical hours. And we see that in some of them who go into these quick clinics, even though they even have a supervisory doctor, because they're unsure. They overprescribe antibiotics, they overprescribe steroids, and then we as primary care physicians are dealing with the fallout of that. So I think of the clinical hours, to be working in a beauty shop, a cosmetologist, 1,500 hours of practice hours before they go, 1,000 hours or more of clinical psychologists after they've already had their training hours. We don't have any interns or internship or residency for nurse practitioners, and I think we're thinking about launching something that will inevitably cause medical malpractice, will cause injury to patients because of just being not intention, but just being new, not having oversight. I wouldn't have any problems in my 5 minutes.
I'm sorry. Thank you.
That's fine. I just feel passionate about it.
Well,
Okay.
we appreciate you being here. Bear with us for just
All
a
right.
second. Are there any questions for this witness?
To inquire.
Go right ahead.
Now, are you aware that this has taken place already for the last 2 years because of COVID?
Well, there's a lot of things that have taken place because of COVID. I do some telehealth, and all of a sudden, for the last couple of years, I can see people in Nebraska, and I can see people in Minnesota, and I can see people in Pennsylvania. And, that doesn't mean that should be the norm when it's not a state of emergency.
Okay, so would there be anything that you would be okay with? Could we come with a compromise? What if we were to just make this where it just affected rural areas?
Well, in some ways, if you're in a rural area and you're in a clinic by yourself, which often if a nurse practitioner is, she still needs a physician oversight, somebody to be calling, somebody to be checking with.
Yeah, I get that.
I don't think that being independent with no hierarchy of checking oversight is a good thing, even in a rural area.
So I still think they do have oversight in there. Yeah, the collaborative practice agreement is still in place that they have, so that still exists.
So what does working independently mean?
Where they don't have to have somebody in that building?
Mm-hmm. Well, they've had that for a while. I mean, but with a collaborative agreement with people who are there overseeing, checking their
Maybe we
machine.
need more language to strengthen that collaborative agreement that exists to make sure that everybody knows that that's not going away. So there is still oversight, because I do think that there needs to be some oversight. But at the same time, these rural areas need to have somebody in there serving that area.
Well, unfortunately, it's not necessarily the nurse practitioners who are the ones who are there.
I go to a nurse practitioner, and I've always been happy with my nurse practitioner. Thank you.
I didn't say anything about being happy with your nurse practitioner. Yeah.
Thank you. Representative Thomas,
To inquire, please.
proceed.
Good morning. Thank you for being here.
Sure.
Although you may not have any way of knowing this, I'd be curious your thoughts. We frequently hear that, well, they've been doing this for 2 years, but in effect, some rules had been relaxed. But have you changed your practice at all in terms of how you're interacting with your nurse practitioners in these past 2 years?
Well, I don't have any they're just all down the hall from me. They're in my office.
Right. So, but
And
has your practice
we
changed
as a
at all?
medical group have not changed ours.
Okay, and that brings me to the point I wanted to make, that very likely the vast majority of people are the same ones that were in practice before and are still doing the collaborative practice agreement that they were doing pre-COVID. So to try to make implications that, well, this has been happening on a wide-scale basis for 2 years is very likely untrue. So I think most people are still practicing the way they were practicing. So it's very difficult to evaluate because we don't have data. So,
True.
and to the best of your knowledge, like I said, for your own practice, the people that you're interacting with, COVID or no COVID, your interaction, your collaborative practice agreement hasn't changed, hasn't loosened up in the past 2 years. Thank you very much.
Representative Lewis,
To inquire.
proceed.
Thank you. Good morning.
Morning.
Thank you for being here today. And I want to clarify, have you read the bill at all?
I just read a summary of it. I haven't read the bill.
Okay. And I understand a lot going on, but on page 4 at the top, it
Do you have a
specifically
copy for me to look at?
it specifically says talks about collaboration with the physician. That does not go away. What this does is just extends the waivers that the governor had during COVID with the 75 miles, the chart review, and working 1 month with the physician. But for new grads, I understand what you're saying. I'm a RN, BSN. I remember what it was like being a new grad, you know. The RN means now you're a real nurse. And that first 6 months was pretty scary. So if a collaborating physician were to work with a new grad APRN, they could absolutely have their own training program with that clinician. That option exists.
Well, I don't think a month is enough to work independently, to be honest. I mean, we do that with our new people coming in for a month, but I don't think it's enough. I mean, it's enough for the overseeing physician to get a handle on where that person is in their amount of knowledge, but that doesn't, usually in that whole first year or two, there's lots of close interaction and oversight.
Okay, well, great, and thank you for that. And the physician and the APRN, they can decide what works best for them as far as collaboration. It doesn't, you know, they can do for a new grad longer if needed. Thank you.
Right, you can't really afford it longer than that. Basically, as a private practitioner, you know, basically they're seeing people with you, so you're not getting any revenue from them, but you're paying their salary while they're working with you. So you can't really afford it for too many months while you're paying their salary.
Thank you.
Okay.
Thank you. Can I want to ask you a question then, because I'm not sure I understood. Maybe you can help me with this. In your statement before, you said that the 30 days was not enough time, but then just now I think you said that you can't afford to take more time. Mm-hmm. So
what I'm talking about is a whole month, they're not seeing their own patients. They're seeing them with you the whole month. And then after that, they start seeing their own patients but on a much lower schedule and timing than you normally would, like maybe 2 an hour. And then it goes up to more. And during that time, they're working right next to you. So there's a lot of going back and forth, but they're not seeing nobody. I mean, they're not billing or charging or seeing anybody by themselves the first month.
Sure.
But that would be hard to do for like 6 months.
Okay. So let me ask you this question then. You currently have APRNs that you work with, correct?
Yes.
So what was your training schedule like with them?
The nurse practitioner I practiced in Wisconsin for 10 years before I moved down there, and she was already a part of our practice. That's 20 years ago. So she was already fully in the system, as a part of our group before I joined it.
Okay. So if you were to add an APRN in your office, do you have any kind of training schedule set up for what that would look like?
Well, one of my partners has just added somebody, and they're in the midst of that 1 month.
Okay.
Of just having them go around and seeing and telling what they're doing, and then they will launch into that really reduced schedule for a few months until they feel comfortable ramping it up.
Okay. Thank you very much. I appreciate it. Thank you for coming in and testifying. Is there any other question for the witness? Yes. Representative, proceed.
Permission to inquire.
Proceed. Yeah, go ahead.
Just a quick question. With the group that you work for, if you would find an issue with your nurse practitioner, would you feel comfortable firing that nurse practitioner with the group that you work for, or would you feel that you should not because there could be fallout for you for sending them down the road, basically?
I'm in a multi-specialty group, so that person would have the same HR process and due process as a provider as anyone else. I mean, it wouldn't be I couldn't just fire them.
Yeah.
But there are certain things somebody could do that you could say, we need to start this process, unless it was something, illegal or something like that, and then would be like,
But do you believe that the organization you work for, they would take your advice if you feel this nurse practitioner is not
progressing in their clinical skills?
If there's issues there.
Yes.
So I know it's your license that's on the line.
Right.
If they make a mistake. My wife's a pharmacist, so I definitely understand that. So, and I know there's certain ones that potentially could be concerned, certain physicians, if they're the organization they're representing really wants that nurse practitioner there. But do you feel that's part of the issue, or is that,
No.
You don't think that's an issue at all?
I don't know in other organizations, but in my organization, I don't see that as an issue.
Okay, so if you'd have an issue, you believe your organization would take action and remove that nurse practitioner off your
right,
agreement.
or put them in some sort of remedial training that would bring them up. I mean, we don't just try and say bye,
Yeah, no,
unless it's really egregious.
Yeah, no, I totally understand. All right, thank you.
Okay.
Thank you, Representative Cook.
Are we done?
I think we're done. Thank you so much for your testimony and being here. Any others in opposition?
Thank you, Mr. Chairman, members of the. Yep, that's no problem. Thank you, Mr. Chairman, members of the committee. David Jackson, registered lobbyist on behalf of the Missouri Dermatological Society and the Missouri Society of Anesthesiologists, here to testify in opposition to House Bill 2434. I want to start off by, recognizing there's a lot of frustration with the physician community on this. I know that a lot of you probably feel like the physicians and our lobbyists have been obstructionists to this issue. You've got access to care issues in your district with not enough doctors there, and CDUS is blocking this movement over the last several years. Representative Lewis and I spoke yesterday, and she, I think, made a good point in talking about how the fight that we have here sometimes that gets pinned as doctors versus nurses is very unique to this building. When you go into hospitals or clinics or doctors' offices, they're working together, they're saving lives, they're treating patients, and they're coordinating care. And I think starting with us, we agree we need to do a better job of listening and make this more about the patients, because that's what this is about. And trying to understand exactly what problems you're having and how we can revamp and retool our statute to try to make that better and increase access to care while also maintaining patient safety. We're here to work with you as a solution, but we also feel that this bill, as drafted, is not that solution. I don't think anybody here is opposed to doctors. I think if anybody, if your opinion is that a doctor and nurse have the same skill set and that a nurse can do everything a doctor can do, by all means, that's a different view. Vote for this bill. But I think most of you, in talking to you, I think if you could have doctors in your area, you want them. You want doctors to be a part of your care. And I think I want to provide a little context on the background of collaborative practice arrangements and how all this started. In 2008 is the last time we really revamped everything with collaborative practice arrangements. It's whenever prescriptive authority was added to allow nurse practitioners to prescribe Schedule III opioids, narcotics, and certain drugs. And as part of that, everybody came to the agreement that it was appropriate to have a nurse practitioner within a 75-mile radius, or at that time a 50-mile radius, and for them to review charts to make sure that the patient had access to that physician if needed to, and that physician was in line and coordinating care with that nurse practitioner. The 30-day preceptorship was added because that physician's medical license is on the line. Whenever they are lending their license and liability, we didn't think it was a lot to ask for that nurse practitioner to work in the same office as them in order to better understand their practice habits, beyond just what their degree and credentials might be. We heard yesterday that somebody, or last week from a nurse practitioner that, they would, I think, quote, search for the cheapest option available for a collaborating physician. We want them to search for the safest option available out there. These barriers are not barriers for nurses. I want to be clear in that the Missouri Society of Anesthesiologists and one of the clients I'm testifying for are not in collaborative practice arrangements. They have a separate statute. They're here raising the flag telling you, watch out. We want to be careful that bad doctors are not out there signing onto an agreement to allow somebody to prescribe drugs, treat patients without living by the patient and without reviewing any of the charts and just recouping money from it. The economics is not difficult. The doctor gets paid to do a collaborative practice arrangement. But we want teeth in there because the number one priority for us is to make sure that the patient has access to see that physician so they can coordinate the care together. Our concern with this bill is that it eliminates mileage requirements, it eliminates chart reviews for non-controlled substances, and eliminates that 30-day preceptorship. I'm not suggesting that all of those are the best solution, and that's why we're here to come to the table. There are things that have changed since 2008. But our goal is to work with all of you and the stakeholders to make sure there's something that is in place to make sure that the physician is still involved in the care and the patient still have an option to see that physician and work with that physician. Every other issue that we deal with in this building, we talk about facts and data. When we're talking about education issues, we're looking at APR scores, graduation rates, and everything else. The only data we've based this off of so far is that there's no articles about people dying. I would argue there were a lot of people that have died over the last 2 years. I'm not suggesting that's because of nurse practitioners, but I am suggesting that we dig a little deeper and let's look at how many nurses utilize this waiver. Let's look at how many nurses were practicing outside of that 75-mile radius. How many charts were reviewed? And let's look at other states and best practices to come together to figure out a solution that's best for patients.
Thank you, Mr. Jackson. Are there any questions for this witness? Yes.
I want to pick up kind of where you left off, where we ran out of time. So I know for me personally, and probably for most of the committee, we have a real interest in improving access, quality, and reducing the cost of care. And it seems like a lot of these types of bills that we hear in this committee are designed to do exactly that. But as you indicated, on every single bill, we have various groups that come in and testify in opposition. And we always ask questions about, well, why are you opposed? Can you point to anything in particular that shows that this is actually going to harm patients? And all the time, our questions are met with crickets. And that is incredibly frustrating when we have nothing but opposition on these types of bills, but there's no real data to say that this is actually going to hurt people. And you led off with, we all are looking at patients, and that's the focus, is what can we do to help patients. So what I want to know is, when you ran out of time, you were talking about that this does harm patients. So can you share a little bit more about that? We have these types of arrangements in place around the country, is my understanding. It seems like that if there was a great deal of harm coming to patients because of these types of arrangements, there would be data available. So what data do you have that shows that this does cause harm to patients?
Yeah, and I want to be clear in that our number one focus, again, is making sure the patient has the option to have their physician involved in their care. And I think, I'm not going to, try to use scare tactics to tell the committee that everybody's going to die if this bill passes. What I am suggesting, if you look at the data to show, if you look at medical malpractice claims data, the highest malpractice claims against nurses are related to diagnosis and medication and treatment of care. Now, do doctors make mistakes? Absolutely. But if you look at those malpractice and claims data, all of this best practices show that the best way to increase patient safety is to collaborate care, documentation, so you have common knowledge among all the providers about medication involved. And we're looking right now at most of this focus has been about primary care. But this bill is drafted could allow somebody to open up a women's health practice and, start mixing with medications while somebody's pregnant. You could have somebody diagnosing cancer. You could have, I think if anybody on this committee has somebody in their family who, may be treating or dealing with cancer or serious illness, may want the doctor involved. If you have a kid who is on a college campus getting, prescribed depression medication, you probably want that doctor involved in some case, not necessarily on campus, but involved in the care. And I think what I'm suggesting, I don't have all the answers, and this isn't a gotcha thing where I have data, on every aspect of it. What I'm asking is that we scale this back and look at, whenever in 2008 we passed all of this, we heard the same arguments. This is going to increase access to care with prescriptive authority. When we amended it to allow, telehealth remotely, we heard the same thing. When we talked about a 28-day waiver under the mileage requirement that's also been amended, we heard the same thing. But one thing I would like to see in this bill is some reporting mechanisms, statistics, so we have some things to base this off of as we make our decisions, and not just make it based off emotion.
Thank you, sir.
Thank you, Representative. Any further questions? I'll come back to you, Representative Dahl. Representative Kelly,
To inquire.
proceed.
What can you kind of go over, and maybe you don't know, I don't know, when a collaboration takes place and when it's a distance collaboration, how does that collaboration take place?
Yeah, it's a good question. And I think also a question that would be interesting to find data. Maybe this data is out there, regarding how many nurse practitioners are in collaborative practice arrangements that aren't in an office with the collaborating physician. But to your question, right now, a physician is required by law to review 10% of the charts for patients, and it's increased to, remember, it's 15 or 20% when it involves controlled substances. However, the doctors that I talk to that's closer to 100% that they're reviewing. If you have a doctor who complains about this being a pain, that they don't want to deal with the charts, we don't want that doctor collaborating, in our opinion. This is a consumer protection issue for us. Now, I also think that, as you and I discussed, chart reviews may not be the best option, and we're willing to consider that and look at what's changed. I actually think that the gentleman that testified from Chestnut Health in last week's hearing and talking about kind of a peer review process and sharing patient, interactions, over telehealth and looking at things may be a good addition to consider. And I think we need to look at those best practices. But the different physicians and nurse collaborators do it different ways. Some physicians are in the clinic, at times. Some of them, are practicing remotely the entire time. But there is a collaboration, and it's designed for the physician to be involved with that patient's care, and for that patient to have the option to see the physician. I don't know if that answers your question.
Well, so when chart review takes place, is it through the computer? Because they all enter their documents online now. And so all that takes place online, correct?
Yeah, it's through electronic medical records, and I think we do have one more physician here who's going to testify who might be able to speak a little bit more to that. But from, again, I'm not a physician, but from my understanding, if a nurse practitioner sees a patient, enters it into the medical record, then the physician is required to go back into that record and sign off. Now, I have heard from some doctors who say it can be bureaucratic, not because they don't want to do it, but because when they enter in the system and shoot it in, it can be a black box. Now, that may be an organizational issue, right, that they need to figure out. Maybe some practices have figured it out better than others. But I think it's something we need to look at when I talk about coming to the table and retooling all of this to make sure it's best practices. I think that's something we need to consider.
But that same collaboration could take place in that same building too, right?
Correct.
Where they're not talking face to face, it's all electronic.
Correct.
Okay, thank you.
Thank you very much, Representative. I will just state that, just make clarification, every 14 days, 20% of the files need to be reviewed for controlled substances. So,
and this bill, to be very clear, this bill does not touch the controlled substance portion of those chart reviews. That is left intact. Now, we are concerned about a physician being, if you have a physician in Joplin who's supervising, a nurse practitioner in Hannibal who's prescribing controlled substances, even if they're reviewing that percentage of the charts and they're nowhere, and that patient doesn't have the access to see that physician, that is concerning to us.
Representative Dahl, proceed.
So I appreciate your willingness to work on this. I guess my question is, we heard testimony, I think it was last week, and I believe it was on this bill, that said doctors aren't actually reviewing these charts. And I know you said your doctors do, but we know that there's a lot that aren't bothering. They might have to sign off on it, but they're not spending, hours of their time. They're busy, right? I get it. So I guess my question for you is, do you have thoughts on what a better way would be to still have that collaboration and some oversight, but to not have the burden of chart reviews that is it? I mean, no one's monitoring to see if a doctor is actually doing that, right?
Yeah, it's a good question. And that's where I think, when we talk about turf wars in this, and I know there's a perception that this is doctors trying to protect their money. I want to go back to the point that a doctor gets paid to be in a collaborative practice arrangement. So the doctors that, if you have a nurse practitioner who's saying they can't find a doctor to collaborate with them, I think we need to look closely. If you have, 15 doctors in a metro area that aren't comfortable putting their liability on the line to get paid for that collaboration, is patient safety something we should consider? But, to your question, I think we do not stand behind any physician who doesn't want to review charts or have that oversight. In our opinion, those doctors should not be in collaborative practice arrangements, and if they're not following the statutory guidelines, they should be disciplined by the Board of Healing Arts, and we'd be the first to file those complaints. We think that's an accountability measure and a patient safety matter. Now, is there more, a better way to do that? Maybe you have the physician on site working and doing face-to-face review or collaboration on charts with or medical records with the patient with the collaborating nurse practitioner. Maybe there's things we can utilize through telehealth. Maybe we can look at something like they do in Illinois. I don't have all those answers, but we're willing to roll up our sleeves and try to find those answers. We just think that if doctors aren't filling out chart reviews, the answer is not to get rid of them. It's to find a better solution to keep physicians engaged.
What do they do in Illinois? I'm curious.
So the gentleman who testified with Chestnut Health, if I understood correctly, they have, I can't remember the frequency, maybe monthly, maybe even weekly, where a physician is over telehealth with them, reviewing different patient cases and scenarios and patterns of behavior, if I'm repeating that accurately. I can't speak to the effectiveness of it. I think let's look at ratings there versus here and kind of look at the data. I don't know, but that could be a solution.
Gotcha. Okay, thank you.
Thank you. Quickly, how many more people are here to testify in opposition? One. Any other folks here to testify in favor of that did not testify last week? Okay, so, all right, we're going to go with one more question here, Representative Davidson, and then we're going to move on to the next witness.
I believe you touched on this already. There is a liability that a physician carries, though, in each collaborative practice that they enter into, even if it's the nurse or the physician, the PA who actually practices, I guess, the malpractice. Is that correct?
Yeah, so there is a liability in the physician's license and medical license that's on the line. If you have somebody who opens up a pain clinic and is prescribing opioids and there's a claim that doctor is going to be included in that claim and they have liability affiliated with that.
Could you share why you think that liability isn't enough to promote healthy collaborative practice between physicians? And
I wish it was representative, but for when I hear from and talking to doctors, you will hear it's kind of a common theme where there will be a nurse practitioner shopping around offering to pay a physician and hire the cheapest one. There's websites how to hire the cheapest collaborating physician, and there are some doctors who are willing to roll the dice and say, if I don't have to do much and I just have to in this case sign off on some charts under current law or maybe no charts and roll the dice and get a retainer every month for it, I'll roll the dice. And that's something that we don't think is in the best interest of patients, because when patients, this is an area, I'm all for getting rid of regulations and barriers, but when patients go into a healthcare setting, they trust that somebody vetted that person, is qualified and there's a physician involved in that care, and that group is this committee. And so I think we need to be really careful before we change these laws.
thank you.
Thank you, Mr. Jackson. I believe that if I'm speaking correctly, that you have agreed, along with the bill sponsor, to meet sometime next week.
Yes.
To try to come up with some solutions. So I appreciate your efforts on that.
Representative Lewis, I'll follow up with you. I know you had a question. Happy to.
Thank you. Next one up for opposition. And let's try to keep it, I hate to do this to you, anybody that comes up to testify in opposition, if we can keep the comments to a minimum for new comments, because we are running into time restraints for the next bill.
Thank you. I'm George Hubbell. I'm an obstetrician gynecologist. I herald from the Lake area. Dr. Thomas is the representative of my fair and fine district. I want to just kind of qualify my own appreciation for having nurse practitioners in my practice for over 3 decades. I've had 2 have retired. I have one actually that was my age in my most latest part of my practice, and so the value and the things that they provide for my patients and my practice is enormous, and I have all the respect for them. I continue, and in my last 3 decades of practice, I've trained, I've preceptored, I've gone through didactics with nurse practitioner candidates, so I feel like I'm versed to talk to you today or to answer your questions. Curiously, of all the nurse practitioners I've worked with, and this is anecdotal, when I query them, would you like to be independent? Flat answer, no. I've never had anybody tell me they want to be independent for a number of reasons. I think they know that the practice of medicine is a team at this stage, and we're, as a physician, we're the captains, and there are a lot of practitioners et al. Under us, whether that be a PA, whether that be a nurse practitioner, various people in mid-level categories. To relegate someone to not have regulation, who heretofore has been educated and as well only experienced being dependent upon a collaborating physician, I think is a large step. There are a couple things that I think that really we haven't really mentioned, and that would be in a physical sense. I think the physical note on this bill is $0. I would vehemently disagree. When you're an independent practitioner as a family practice doctor or a rural physician, a general practitioner, your insurance runs about $6,000 to $10,000 a year. So I think you could do the math and see that anybody that wants to be independent in the nurse and the APRN category would be faced with insurance, or the system or the corporate entity that employs them would be faced with insurance. And you can do the math. There are quite a few thousand of practitioners in our state. Additionally, to have a new category of independent APRN, in my mind, and I think probably in the legislature's mind, in certainly Department of Health and Senior Services, would require someone to have a review board. At present, there is no review board. They're under the division of the nursing board. Unlike PAs, unlike MDs, unlike DOs, unlike assistant physicians, they're all under the State Board of Healing Arts, where any complaint, any malpractice filing is 100% review. And I think that really does keep or safeguard and keep our state safe. Our Board of Healing Arts, I know, review over 1,000 complaints and cases that have been filed for malpractice and involve, if your name's on the case, you're going to have your day in Jeff City. So I think to set up a board like that would definitely have some physical consequences. And if you are trying to be parsimonious with the state's dollars, it is not going to be a $0 physical situation. Finally, I think Dr. Kiekhaefner alluded to this earlier, but we're fortunate to have an assistant physician category of practitioner in this state, and we're unique. I think 5 or maybe 6 states now have that, whereby somebody goes through their entire graduate medical education. They're an MD, they're a DO, but they haven't done a residency for whatever reason, and then they decide they want to practice. Well, unless you can go back and get into a residency, you are a tweener. And in this state, we've allowed collaborative agreements under a licensed physician to occur, which has been a very successful program. We probably have 100 physicians now in the state that are practicing as assistant physicians. So the assistant physician has 10,000 hours of training, and yet they're under collaboration and chart review. We're talking about taking a practitioner who has 500 hours, or 1,000 if they're a doctor of nursing, those are the requirements of clinical training, and propelling them into independent fashion, yet we have an assistant physician category that does not allow that. So I think, again, they're not tantamount, but again, we're opening up a can of worms if we make these practitioners independent. I probably yield my time.
Thank you. I apologize. I wish we didn't have these time restraints, but unfortunately we do. So I appreciate your testimony. And is there any questions? Yes, Representative Davidson.
Would you please define really quick what you mean by independent?
By independent, no one, making medical decisions without, on de novo on their own, without oversight. Again, if you restrict and you let someone come out with 500 hours of training, and I'm sure there are corporate medical entities that would allow such, they would not be under the guise of any higher order caregiver.
Does a collaborative agreement, though, then preclude that arrangement? I mean, doesn't it sort of negate that? Isn't there some sort of supervisory role?
Yeah, as a collaborator for 30 years, I reviewed 100% of my charts with my nurse practitioners.
And this wouldn't,
and I continue to.
And this wouldn't prevent you from doing that either. Correct?
Doesn't prevent.
In
no,
fact, it still requires.
But it doesn't. It doesn't require.
So it's still
all of a sudden there would not be a requirement for any review.
I think it does require, though, that APRNs do enter into collaborative agreements in order.
Collaborative agreement, but chart review does not require any. So you can't see if someone is off the mark. You can't evaluate whether someone is.
Well, no, but a physician could do all of those things. It doesn't prevent them from doing any of
It
those.
doesn't prevent that, but it doesn't mandate.
Well, it mandates a collaborative agreement and then leaves up to the risk averseness regarding liability of the physician to determine how best to exercise that collaborative agreement.
I can give you an example in my discipline.
Mm-hmm.
And maybe this is a little extraneous, but just the same. There is a practitioner in this state, a lay midwife or a certified professional midwife that heretofore did not practice until about 2007 or so.
Yeah.
And they are independent practitioners. They are not required to collaborate. They are not required to have chart review. There is no review board to review malpractice, acts of omission, acts of commission. They really don't have any review. I can tell you I've been the de facto chair of the Maternal Mortality Committee reviewing every maternal death in this state since 1999. And I've done the due diligence on this, and I've looked at what has happened since institution or whatever, relaxation in that requirement to allow lay midwives practice in our state, have home deliveries, and not any regulation or any collaboration because they can't find collaborators.
Yeah.
Now, the infant mortality, the fetal mortality rate is 20 times higher when somebody delivers at home in this state.
Yeah.
The maternal mortality is over 3 times as high in that category of person who's doing a home delivery with a lay midwife.
I guess what I would say is you make good points, and that's a reason not to get rid of collaborative practice altogether. I'm considering the legislation, though, not in the context of creating independent APRNs, rather collaborative agreements between physicians and APRNs that is more locally managed to that particular circumstance. Appreciate your answers. Thank you.
Yeah, again, the local issue, though, I don't think anybody really has a true issue with the realm or the size or the radius of coverage for that collaboration. It's, I think, 75 miles now, if I'm not mistaken. And, I know there was testimony last week about being 76 miles away and having to, per case by case, get a voice order to see a patient. I think those are things, Representative Kelly, that could probably be relaxed and have a friendlier, more collaborative, less burdensome situation.
Thank you for your testimony, sir. Again, I would love to take questions, but real brief.
Thank you. I just wanted to say I'm going to be posting on the witness forms some testimony from Mark Terramarina, who is a physician, a GI physician, many, many years in practice. I know that you're well familiar with him. He's on the Board of Healing Arts, and he is in opposition to this bill. And his experience with mid-level practitioners and nurse practitioners in particular, with some suggestions on how this bill could be adjusted. But I would just encourage people to go look for that. I'll get it online. I didn't know how to do that because he sent this to me. So I will post this under with his information under witness testimony. So thank you very much.
Thank you, Representative. Okay, thank you very much for your testimony, sir. Again, due to our time restrictions, if there is there anybody that is here from out of town that is in opposition to this bill? Okay. I hate to say this, but quickly, for those who are here from out of town that are in favor of this bill, come on up and if you can keep it down as much as you can. I apologize. I know this is an important issue, but unfortunately we don't have the time that we used to have. So we appreciate you being here.
You're fine. I'll talk quick. My name is Susan Klotz. I'm a nurse practitioner in Ash Grove, Missouri. And as a result of The emergency waiver that was put in place in March of 2020, when I lost my position at Mercy for COVID saving measures, it left numerous amounts of my patients with special needs and disabilities without care, without the care that they need for quality of life and function and to maintain. So I was able to start my own practice independently. I do have a collaborating physician during this time, who I was able to arrange out of Columbia, which would have been past that 75-mile waiver. So, you know, without this waiver, I would not have been able to acquire somebody for me to be able to start this practice. Within 2 weeks of me losing my position at Mercy, I had a patient pass away from intrathecal backlift withdrawal, which is life-threatening, but it's not a well-known treatment, and that's a treatment that I provide. I work in physiatry, which is physical medicine and rehab. And in the Springfield area, it's a very limited specialty. And I think there's a total of 9 physicians that are able to, that would be adequate collaboration under the current statutes. 7 of those are in non-compete clauses and are not able to collaborate with me because I'm an independent practitioner. So that leaves me with the options of hiring from a physician collaborative group, which are headhunters. They contact you and say, hey, we have a collaborating physician. Now that physician may be in pain management, but may have never touched a backlift pump. So, you know, not having this waiver in place really limits my ability to care for these patients. I do 98% of my practice as house calls. There's a huge strain on our system right now as a result of COVID, and I think we're going to continue, even if COVID's under control, we're going to continue to see the fallout from that. So for us to go to the doctor, we get up, we get dressed, we take off work, we make sure we get there. For one of my patients, it takes a nurse, it takes a guardian, it takes special transportation to get their wheelchair into their van, it takes special accommodations. Okay, talk quick. And so you have a high, rescheduling rate for patients, which puts a strain on the medical facility. You have staff that are paid to take care of them during that appointment time, and they can't come. So I feel like the 280 some patients that I have, that I'm able to go out and see them in their homes, that I'm able to be available to them 24/7, that I'm able to provide safe, adequate care for them. It's monumental, and I think that the 75-mile barrier rule is the hardest thing for me to be able to get along with when it comes to being able to provide care for my patients. Because those that need it the most are the ones that I'm going to have to tell, you're going to have to come into the office, and that's a 2 to 4 hour trip for them. That's a day off work. That's a lot of sores. That's a lot of pain, and that's a lot of spasticity for a 15-minute procedure. So I get the concerns. I'm a practitioner. I remember what it was like being brand new. And I think that the key word there is collaboration. We have a relationship with a physician. We just don't have the checkbox requirements for that physician to work under. And honestly, when I first started practice, my physician did review 10% of my charts. He did it in writing. In the past 2 years, my collaborator hasn't reviewed my charts. Doesn't mean we haven't communicated, just means he hasn't had to open charts to review them.
Very good. Thank you.
You're welcome.
Because of time restrictions, I'm going to go without any questions at this point in time. I appreciate your testimony. Thank you very much for driving to the Capitol. We appreciate you being here. There is one other that is in favor of. Come on up. Okay.
I'm David Winton. I would be very brief because I know you all have other things to do.
Thank you,
I
sir.
wanted to make 3 very quick points. The first point is that we talk a lot in this building, and we're all friends back here, so we all have worked on this. This has been going on for over 10 years, probably further back than that, in earnest. And when we do these bills, we talk a lot about the physician being able to figure out what the right thing to do is based on their scope of practice and their ability in the field. When we passed a telehealth bill 4 years ago, all of us together said you should be able to provide services vis-a-vis telehealth if it's in your scope of practice and you can maintain a standard of care. We trust physicians to do that. All this bill says is that we're going to trust the physician collaborator to come up with an agreement with that nurse practitioner to be able to do that work. That physician has gone through medical school. They're exceptionally smart people, and they know their license is exposed. They will take the necessary precautions that they think. And the third point I wanted to make was, so you all wanted some data. So Cox Hospital, I'm Dave Winton here, representing Cox Hospital and BJC. For Cox Hospital alone, we had 1,000 referrals over the last year and a half made to home health agencies by nurse practitioners because we had this waiver. That is 1,000 people that were getting care that they needed in an efficient way through a system that may have had a much more difficult time getting that care if it required a physician's order at that point. So I think that's a pretty astounding data piece. But this bill is not independent practice. It's not earth-shattering. Most other states around the country have done this and well beyond and have not seen any ill effects out of that. Mr. Chairman, thank you.
Thank you for your testimony. That being said, anybody here to witness in informational only? Seeing none, that will conclude our hearing today for this bill.